Thank you. If I could direct my questioning primarily to Mr. Harper. And before I do, Mr. Charles, your name is at the bottom of the Australia Institute letter or submission, but you've said you're only here in the capacity as the Centre for Public Integrity. Are you not here for both?
I'm not here for both. I was asked to come along for the CPI. I knew that David Harper was going to be here to represent the other body. I can speak in any answer to any of your questions. I'm here simply for the CPI at the moment.
So when your name appears at the bottom with Stephen Charles, Mary Gaudron, David Harper, Paul Stein, Anthony Wheely, Margaret White and Carmel McClure, but you're not going to speak to that letter?
Look, I can do so if you wish to ask me questions about it, but I'm not here for that purpose at the moment.
Oh, thank you, Mr. Charles. I'll go back to Mr. Harper. Mr. Harper, could I take you to the report that's at the end of that letter, and in particular take you to page 7, please?
I don't have ready access to it on my equipment, I'm afraid.
I'll do my best to summarise it. You probably don't need to refer to it, and if you could take it as a given that I'm not misleading you about what's in it.
Certainly, I'll take that as a given, yes.
Thank you. So on page 7, it has a table up the top, and it's called Table 1, Comparison of Anti-Corruption Agencies in Victoria and New South Wales. And the date range is important, and we'll get to why. It says 2012 to 2021. And tell me if this is correct. ICAC was established in New South Wales on or about 1988, and IBAC in Victoria on or about 2012, and that's the reason that date would be chosen. Is that correct?
Yes.
So ICAC in New South Wales is a more mature organisation that has been around for a longer time.
Yes.
In that table from 2012 to 2021, the case has been made that Victoria holds less public hearings, and the table under Victorian public hearings notes that there are 5. Can I respectfully suggest that this is in error, and the IBAC annual reports, which are published online, note that there were 8 in this period and a further 2 since?
I don't challenge your conclusions. I'm not privy to, I'm afraid, the way that the committee prepared the figures which it put before the committee, but I have no doubt that you have made the correct calculations.
And perhaps when we get to the next session, Ms McLeod will clarify, because her submission notes that there were 8 in that period as well. And the website says that there was 10, but 2 of which occurred after that date range. There's another way to make the comparison, and the comparison here is it says public hearings 45 for New South Wales and 5, or let's say 8 for Victoria. But there's another way than just aggregate hearings, and I want to get your opinion on that. The other way to compare would be to compare total hearing days. And I accept that New South Wales uses the language compulsory examination, but I will say hearing days from here on. And they can be private or public. And I would suggest that this is more helpful because some hearings may be mundane and short and others are complex and long. Do you accept that that will be another way and perhaps a better way to compare?
Well, certainly another way to compare. I accept that respectfully, yes. Better, I'm not sure. I am of the view that it is significant in looking at the question whether or not there should be exceptional circumstance before a public hearing is conducted, that there's such a wide discrepancy between the number of cases in Victoria that were conducted in public and those over the same period in New South Wales. But yes, I think it's perfectly open to subject that broad conclusion by looking more particularly at the number of hearings, public or private, that the two bodies have conducted over that time. I don't seek to defend the conclusion that we've drawn on the basis that it is one that is clear from the figures, from any kind of figures, except the fact that the discrepancy is very great. And it is, I think, quite legitimate to conclude that one of the reasons for that very great difference is a reluctance or an inability in Victoria to find exceptional circumstances where that is not a problem in New South Wales.
I'm just going to, we've done the work on hearing days. I'm just going to quickly go through it and get your opinion on it. The IBAC reports only record data from July 2014, and we can assume it's because they were finding their feet, but that's when they started recording data. So from the period July 2014 to June 2021, we noted, and I'm happy to be corrected, and rounding up, that 53% of the hearing days for NACC in New South Wales were public, and 28% of IBAC's hearing days were public. And we accept and note that IBAC in that comparison still has fewer hearings, but would you accept that that's nowhere as extreme as this report seeks to make out, which using the figure of 5 was 9 times as many?
Yes, I would have to accept that.
I'd like to move on to, on that page underneath the table, there's a heading that says, the test is vague and open to litigation. And this is a matter that is covered in not just this organisation, but the Centre for Public Integrity, the Accountability Roundtable, and I'm not sure if, Professor Brown, you mentioned it too, so perhaps it's something that we can save time on. So bear with me as I go through it, because it's important. You all raise it. You've said that the test is vague and open to litigation, and then you quote Fiona McLeod, who's I note here already, and you say, quoting Fiona McLeod, legal experts are concerned that the test invites legal challenges, and quoting Fiona McLeod, it's a lawyer's picnic waiting to happen. The test means that a person who is under investigation may make issue with a commissioner who seeks to hold a public hearing and delay the investigation with a court challenge. And then later it says, the exceptional circumstances test puts the commissioner in a difficult position. It is an unnecessary grey zone that only adds legal risk and confusion. And it's that argument I'd like to address, please. Now, we don't need to speculate about this, do we? Because thanks to Victoria and IBAC, we have a decade of test cases for this very test. And when we look through the 10 hearings, there was only one that had a direct Section 117 case. Does that surprise you?
If you're saying, I take it, that there was only one case where the question of the existence of the exceptional circumstances was a live issue.
That's correct, and I'm happy to go through each one of them. We've got a table that shows when and where it went before the court. And the one, it was the fourth one, so the first one was Fitzroy, then Ord, then Dunham, and then Ross. And it's the seminal case for Victoria, R&M and IBAC 2015, Victorian Supreme Court 374. And it's a case that is referred to in some of the submissions. But when you go through the other 10, including Lansdowne, Gloucester, Sandon, Esperance, Watts and Bredbow, we couldn't locate any direct cases that were brought before the court for this very issue. Does that surprise you?
It does. I'm not querying the fact, but it does surprise me that someone who is accused of corruption and who is facing a public hearing does not challenge the issue of exceptional circumstance. In one case, that challenge was made. I don't know why the other cases did not also involve a challenge. Maybe the very fact that the notion of exceptional circumstances is so vague, so ill-defined, that the cost of a challenge, the cost to the pocket of the person seeking to raise doubts about the issue of exceptional circumstances and bring them to the court was a disincentive. Legal proceedings are often difficult, but they're always expensive, and it's not to be assumed that they can be taken lightly. A corrupt person with a deep pocket would almost certainly challenge a ruling by a commission that exceptional circumstances exist, even if only to create a delay to stop the proceedings for some time, perhaps a long time, while the queue at the court was overcome. So there are reasons why you might not challenge the ruling that exceptional circumstances existed, but there are also very strong reasons why you might.
Thank you, Mr. Harper. But with respect, that sounds like you're speculating. I've pointed you to actual cases, and you would be aware that in Victoria, at least, cases can only be brought for a proper purpose, and that's in the Civil Procedure Act. So is it really the case that you can, before this committee, speculate about plaintiffs using the procedure of the courts and litigation to delay when there's no evidence of that and it's not for a proper purpose in Victoria?
What else can you do but speculate? We weren't present, of course, at the hearings, and we can't say why it was that the exceptional circumstance ruling wasn't challenged. I'm sorry, with respect, I don't see how you can do other than speculate about the reasons why the challenge wasn't taken.
Thank you, Mr. Harper. Just in conclusion, have you read the submission of Dr. James Renwick?
No.
Can I suggest that after this you do? I think it goes to this very issue as to perhaps why the statistics in Victoria are what they are. And it's a short submission, but I'll read it out, parts of it. In his third line, Dr. James Renwick says, "I consider the risk of a successful challenge to any decision to hold a public hearing is small." And he then outlines why, and he refers 3 points, and including that it would be a jurisdictional fact in the usual, and refers to Hetton, Belbird and Colliery's sense. And then also says that the High Court and Minister for Immigration and Multicultural Affairs against Eshetu, as decided in 1999, High Court Australia 21 at page 137. And he quotes at 137, where the criterion of the court, where the criterion of which the authority is required to be satisfied turns upon factual matters upon which reasonable minds could reasonably differ, it will be very difficult to show that no reasonable decision maker could have arrived at the decision in question. It may be otherwise if the evidence which establishes or denies, or with other matters goes to establish or to deny that the necessary criteria has been met, was all one way. And he goes on expanding that and then says, second, provides a suggestion on another provision. Can I suggest that we accept that there are arguments for having public hearings, there are arguments for having no public hearings. I think everyone on the committee agrees with that, and we've got to wrestle with that decision. But can I suggest for all of the committees appearing today, it's unhelpful to engage in speculation when we have an example from Victoria that shows otherwise. It doesn't assist this committee in addressing that substantive question before us. Thank you, Chair.